Mr. Zunino.
Is it Ms. Lawrence? Is that correct?
Yes,
You're an attorney, correct?
correct.
Do you provide legal services or legal advice to the Trump campaign?
No,
Are you paid for any of your volunteer work, or I guess it wouldn't be volunteer work, but are you paid for any of your work on behalf of the campaign?
no.
When you were in this space that you've described with the diagram, did you have a smartphone with you?
I did in my purse.
So you didn't take any photographs of the area?
No, we are strictly forbidden from taking photographs. We don't even look at our phones. On one or two occasions, I looked just to get the time, but we're not allowed to take photographs. We're not allowed to record.
Okay, and how do you know you're not allowed to take photographs?
My ambassador told me the first time I arrived, she said, take your phone out and turn it off.
Okay, that's all I have. Thanks.
Mr. Devaney.
Thank you, Your Honor. Hello, Ms. Lawrence. My name is John Devaney. And I have just a few questions for you. You said that from where you were observing, you could see the counting tables. Is that correct?
Some of them, yes.
And that's where counting of ballots takes place. Is that correct?
Okay, the way I understand it, the counting of ballots occurs in the auditor's room, which we cannot observe. The counting board takes out 75 ballots per tray, and then they go through them, and my understanding is they're looking for spoiled ballots or ballots that should be rejected because of some defect.
So, Ms. Lawrence, your testimony is the counting of ballots takes place in the auditor's room?
Well, if you're referring to counting to match, then yes. But if you're talking about just reviewing the ballots, then no.
No, I'm talking about the tabulation and counting of ballots. Does that take place in the auditor's room, to your knowledge, Ms. Lawrence?
No, that doesn't take place at the Greystone facility, to my knowledge.
Where does it take place? Do you know?
Well, I haven't been to trade, so I can't say definitively. I haven't been to trade. I apologize. Let me clarify.
And is underlying your testimony that you've just given, is it your assumption that as an observer or member of the public that you have a right to observe signature verification?
Objection calls for a legal conclusion.
Overruled. You can answer.
I don't know.
And the act of duplication, Ms. Lawrence, that's not the same as counting a ballot, is it?
Correct. It is not the same.
And is it your testimony that you have a legal right to observe the duplication of ballots?
I'm not going to make that judgment. I'm there as an observer.
And then you said you're not able to observe the work of the auditors. Again, is it your view that you have a legal right to observe the auditors performing their work?
I don't know.
And how often have you been to, I'm sorry, which facility was it again? I'm losing track of the names.
I had been to the Greystone facility 3 times.
And is that the only facility that you have been to?
It's the only facility I was able to gain access to. I was denied access to the Trade Center facility.
And that was when you went at night, which you talked about already, correct?
Correct.
And you went to the Greystone facility 3 times. How many hours each time did you spend there?
On Monday, October 26th, I was there from 12 to 3:30. And on Tuesday, October 27th, I was there from 9 to 12:30. And then again from 3:30 to 6:30.
Okay. So roughly a total of 9 or 10 hours that you've been at the Greystone facility, is that correct?
Yes.
And you said that you saw runners carrying ballots into a room with the door closed. You're not suggesting that those runners engaged in any improper activity, are you?
I'm not making any suggestions. I'm here to testify to what I observed.
Thank you. I have no further questions.
Redirect.
No redirect, Your Honor.
Mr. Binnall, your next witness.
Edward Suarez.
You please raise your right hand and be sworn.
You do solemnly swear the testimony you're about to give in the matter now coming before this court is the truth, the whole truth, and nothing but the truth, so help you God.
Go ahead and have a
Good
seat,
afternoon.
please. Go ahead, Mr. Binnall.
Thank you, Your Honor. Good afternoon, sir. Can you please state your name and spell it for the record?
Edward Suarez, E-E-W-A-R-D, Suarez, S-U-A-R-E-Z.
And Mr. Suarez, what do you do for a living?
I am an attorney in private practice in New Jersey.
All right. And why are you in Nevada, sir?
To help out in the Trump campaign.
Are you observing anything?
Yes, I'm being used to go out and just observe activities.
Okay. Is the Trump campaign paying you a salary to do that?
No.
Are you a volunteer?
Yes.
And have you had the opportunity to observe at the trade building?
Yes.
And when was the first time that you went to trade?
On Monday, October 26th.
Okay. And that was just 2 days ago?
Correct.
What time did you go?
I arrived just before 8 o'clock
All right.
in the evening.
And do you know what did you do when you got there?
Well, when I got there, first I had to find where this facility was. That was a little confusing, especially in the dark, because it was not really particularly well lit. But I eventually came across two security guards, two female security guards. I lowered the window. I explained who I was, introduced myself, what I was there for. They had no idea. They said, but if you're supposed to be here, you can come into the parking lot. So I went in, and everything looked pretty dim and dark. So I parked. I went to the door on the corner where it said Clark County Elections Division, and the offices inside were dim, and the doors were locked, and there wasn't anyone around. So there was a number in the window, a telephone number for people who were making deliveries after hours. So I figured, well, I might as well just call this number and see what I can find out here. And I called the number, and a fellow answered. He identified himself as a technician. He had no idea what I was talking about, but he said, I think you're in the wrong end of the building. He said, yeah, I think you have to go to the other side. So I took my car and I drove. It's only quite a distance. There's another class or entryway on the opposite corner of the building. That was also dim, locked. But I saw vehicles going around to the back. So I figured I'd follow them, and I followed, and there was an area set up with orange cones. There was a metal ramp leading up into a bay, into the building. The door was open, and you could see into the building. There were tables and people inside. I parked. I walked up to a female security guard again that was at the bottom of the ramp, and I introduced myself and explained why I was there. And she said to follow her up the ramp.
Objection, Your Honor. Hearsay.
Objection, hearsay.
He was describing what a guard was saying to him.
Yeah, we're not offering that. Not offering that for the truth of the matter asserted, only offering it for why he did what he did next.
The objection's overruled, and I'll consider it only for that purpose.
Shall I continue?
Yeah.
Yeah. So I followed the guard up the ramp. She asked me to stay at the entrance. She went inside, walked across the floor to where there were a group of people. She spoke with someone, returned to me, and said that if I go to the other side of the building again, to the second entrance that I had gone to, that a security guard would let me in. So I went back there, and I said to ring. There would be a buzzer, a bell, or something there that I could ring. But before I got to the door, he was already there and let me in, and then he escorted me into the building to an area that had been designated for observers in this just opposite of where the bay opening was, going outside.
Okay. And then did they bring you to any ambassadors?
Eventually, yes. At first, the supervisor, Lorena, came over, introduced herself, and told me what was going on in that particular area where the vehicles were dropping off as bins, and explained that those were the vote recording devices for machine voting that was taking place, and that an ambassador would come to give me a tour of the facility.
Okay. And then did the ambassador give you a tour of the facility?
Yes, she did.
And did she introduce herself?
She introduced herself as Shayla, and she took me to the other side of the building again, to the first entrance I came to, so we could fill out a form that I needed to fill out, and as an observer. And then she gave me a tour. Yes. Okay.
And did the tour include the Freedom or Liberty rooms?
Yes, it did. She pointed out where the Liberty room was, the door. There was nothing going on inside, she said, only. She showed me the Freedom room, and she said that there was going to be some activity there in a little while, and that the crew, there's an 8-person night shift, were in the Agilis room, and they were going to be moving into the Freedom room, and I could stay and observe the activities in the Freedom room.
All right, and did you stay and observe?
Yes, I did.
And were they doing signature matching in the Freedom room?
Yes.
Were you able to see them try to match signatures?
I was able to observe. I mean, I was sitting. I think it's been described before. In the center, there are 3 chairs. It's taped out. I could see a couple of screens, and I could hear what was going on.
Okay, but could you actually see the signatures themselves?
I could actually see signatures. Yeah, I mean, to the extent I couldn't read names, but I could make out whether a signature was small or large, spiky or loopy, that kind of thing.
Did you could you see it on all the monitors? Or
No, there's 2.
Okay.
One that was relatively close to me on my right, and then one that was a little further down on my left side.
Okay, and how long did you stay there while they were engaged in signatures?
That whole operation took about, I would say 40, less than an hour.
Okay.
45 minutes, maybe a little more than that. I was out the door. They were done by 9:45 because I was then back at my car by 10 o'clock.
Okay. Did you come back to that facility again the next night?
Yes, I did.
And the next night, that was last night?
That was last night, yes.
Okay. Did they mention anything then about whether the Agilis machine was operating?
The Agilis machine was operating, and Shayla took me directly there.
Okay, and did you observe it?
Yes, I did, and there were 2 other observers as well.
Okay. Did you see anything else of note yesterday when you observed?
I just watched them operating the Agilis machine. The 2 other observers, when they were finished with the one, wanted to have a count, and I asked Shayla if she could ask what the count was. She went to speak with a fellow named Victor, who I think is the team leader. At least that's how she always described him, and always directed all her questions that I had to him. Victor came over and said that there were 9,600 good and 29 rejections.
Okay. That's all the questions I have at this time for this witness.
Mr. Zunino.
Mr. Suarez, you're an attorney, correct?
Correct.
And you have a practice in New Jersey, correct?
Correct.
Are you a New Jersey resident?
Correct.
How long are you staying in Nevada?
Till the day after Election Day.
And when did you arrive in Nevada?
On Monday. This month,
Is the Trump campaign paying for your lodging or your meals while you're here?
I believe my lodging is they're dealing with, yes.
Where are you staying?
Sorry, I couldn't hear or understand. Repeat your answer for me, please.
My understanding is, yes, my lodging was going to be paid for.
And where's that? Where's your lodging?
The Hilton Garden Inn on, I'm not really familiar with Las Vegas, but I believe it's called the South Strip near the airport.
You're not receiving a per diem for meals or anything like that?
Not that I'm aware of, no.
Rental car?
I rented my own car.
Okay, thanks. I have nothing further, Your Honor.
Mr. Devaney.
Suarez, just a few questions. How did you end up in Nevada? Was there a particular member of the Trump campaign who recruited you to go to Nevada?
I have a friend who said, "Would you like to come out? It would be interesting for you, and I've never done this before, and I thought it would be an interesting time to do this."
Is your friend in the campaign?
Yes.
Who is your friend?
Zachary Huff, Huff.
Do you know what his title in the campaign is?
I really don't. I believe he works with Jesse Law.
And were you told sort of what your mission was when you were asked to come to Nevada on behalf of the Trump campaign?
To really observe, ask questions, and then, report my observations, and that was pretty much it.
And were you told to go to Clark County in particular?
I was told to come to Las Vegas.
Okay. And were you, have you been asked to do observation in any other counties in Nevada?
No, no.
And do you know why you were asked in particular to observe in Clark County?
Well, I understand it's like I believe it's the largest county. There was going to be, during mail-in balloting for the first time, there was going to be a big experiment. And it would be an interesting thing for me to observe and be involved with.
Did you talk with anyone in the Trump campaign about why they were sending you to Clark County in particular?
No.
And you said that when you were observing that you could see signatures on a screen, but you couldn't read the signatures. Did I hear you correctly?
Yes, that's true. They were on very small black laptops.
And
Images.
How is your eyesight?
It's pretty good. Yeah, I drive without glasses, at night. So
You drive without glasses at night?
yes, I do.
And did you hear Ms. Diaz testify earlier?
Yes, I did.
And but do I take it you were sitting pretty much in the same place where she was sitting when you?
I was sitting in the last chair. Now I have no idea where people were sitting in relation to her. And we only had 4 pairs of people doing signature verification in the late night.
Right. Okay. But from where you were sitting anyway, it wasn't possible to actually read the names of the signatures, if I understand you correctly.
Yeah, and I have to say I was looking at the signatures, looking at the the images of what they look like. I wasn't really trying to read them. I was just looking to see how they appeared. Were they spiked? I could see spiky ones in different sizes, loops, things of that nature. But I wasn't looking to really read what the names were. But they were identifying the names. So each voter had a number and they said the name, and then they brought it on the screen.
And would you agree that to be able to engage in knowledgeable signature matching, you actually need to be able to read what the name is?
I think you have to be familiar with the person's signature. I mean, I've seen signatures. I know my own signature, and I know how indecipherable that can be.
Thank you. I have no further questions.
Mr. Binnall, your next witness.
Before I call my next witness, very briefly, I would like to, I've realized that I've neglected to move into evidence the picture of the diagram drawn by my witness that has been circulated to counsel, that the foundation was laid for the witness. I understand that this isn't a picture, but of course we, in a case filed this quickly, we haven't had an opportunity to do full discovery where we could have gotten this through document requests. So I think this is necessary to complete the record and just having a diagram showing what the witness described in the record.
We're going to go ahead then and call Fred Kraus instead, Your Honor, while he's restarting his computer, so hopefully we can get speaker.
All right. Will you please raise your right hand?
You do solemnly swear the testimony you're about to give in the matter now pending before this court is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Go ahead and have a seat, and go ahead, Mr. Binnall.
Mr. Hardy, and I'll be brief. Mr. Kraus, can you please state and spell your name for the record?
Fred Kraus, F-R-E-D-K-R-A-U-S.
Are you a registered voter in Nevada?
I am.
Have you cast your vote?
Yes, I have.
Did you do any voting by mail or in person?
In person.
Why was that?
I was just uncomfortable with the mail-in voting process. I wanted to go and vote in person and have my vote counted.
Have you had the opportunity to serve as an observer during this election?
I have.
And did you provide a declaration in support of the writ petition that was filed in this case?
I did.
I want to hand to you what has been previously identified as Exhibit 2 to the writ petition. This is your declaration. Can you please take a look at that and tell us if that's a true and accurate depiction of your declaration?
It is.
Is that your signature on the last page?
It is.
Your Honor, we move to admit this declaration as the next exhibit in line.
We will make a copy of that, have it marked as Exhibit 6, and it is admitted.
With respect to Exhibit 6, which is your declaration, Kraus, do you affirm all the statements that you've made there?
I do.
Do you have any changes or corrections you'd like to make to that declaration?
I do not.
We go ahead and rest on this witness, Your Honor. It's subject to cross-examination.
Mr. Kraus, let me just ask you, as a plaintiff or petitioner in this case, is there a particular person who voted by mail who you would like to challenge?
No.
Has your status as a voter been challenged?
Not to my knowledge.
And you observed as a poll observer on October 15th, is that correct?
I did.
Were there any other days on which you observed?
Yes.
And when you observed, I take it, did you pay attention to the details of the processes you were watching?
As best as I could observe them, yes.
And you were able to watch the preparation of duplicate ballots at a few tables, is that correct?
Yes, the table's closest to me.
And on October 16th, you were permitted to observe mail ballot processing, correct?
Well, I was at the Greystone in the same little observation area that's been previously described. Yes.
And you were able to observe 24 of the 32 tables that were there for ballot examiners, correct?
Well, I could see that there were 24 tables. I wasn't able to observe them in the sense that I could see exactly what was going on at those tables. I could only see the few tables that were very close.
And on October 20th, you also observed the scanning and tabulation of ballots. Is that correct?
yes, at the Trade Center for a short period of time.
Thank you. No further questions.
Redirect.
We have no redirect. We'll go ahead and release this witness, Your Honor. Thank you.
All right, thank you. Your next witness? Will you please raise your right hand and be sworn?
You do solemnly swear the testimony you're about to give in the matter now pending before this court is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right.
Mr. Hardy.
All right. Will you please state and spell your name for the record, Mr. Thomas?
My name is Robert E. Thomas III. The last name is spelled T-H-O, M as in Mary, A-S.
Do you reside in Nevada?
Yes, I do. I reside in Pahrump.
Are you a registered to vote in the state of Nevada?
I am registered in Nye County.
Have you cast your vote in Nye County?
Yes, I have.
And did you observe in Clark County?
Yes, I did.
And in describing your observations, did you prepare a declaration that was attached to the writ petition that was filed in this case?
I prepared the information and someone else typed up the declaration.
Excellent. So do you recall signing a declaration in this case?
Yes, I provided a declaration.
Excellent. And in providing that declaration, was it a 3-page declaration in which you signed on the last page on the October 22nd, 2020?
Yes, that's correct.
And if you had an opportunity to review that as Exhibit 2 to the writ petition to affirm that that is your declaration?
I have reviewed the declaration that I've printed out and that I've submitted to your office.
Your Honor, I'd like to move to admit the declaration of Robert Thomas.
That will be marked exhibit number 7 and admitted.
Excellent, Your Honor. We'll go ahead and allow that declaration to be submitted to cross-examination. Thank you.
Mr. Devaney.
Your Honor, I'll be brief. Mr. Thomas, is there a particular person or persons who have voted by mail who you believe voted improperly and you'd like to challenge?
There are no people at this time. I was never told I could challenge anyone.
And so you have no one in particular in mind, is that correct?
That is correct, Mr. Devaney.
And just to confirm, on October 19th, you were at the Clark County Election Office and you were permitted to observe mail ballot processing, is that correct?
I was at, I believe, trade that day. Yes, sir.
And you observed signature verification stations, is that correct?
I don't remember if it was that day or the following Wednesday.
But you did observe signature verification.
Yes, sir, I did.
And you observed the Agilus machine in operation also?
Yes, sir, I did.
And you are also permitted to observe the counting of ballots, is that correct?
I was able to look in the fishbowl. Yes, sir, I was.
Thank you. No further questions.
Redirect.
We don't have any to redirect this witness, Your Honor.
Thank you, Mr. Thomas. Mr. Hardy, Mr. Binnall, your next witness.
Your Honor, I think at this point in time, we go ahead and rest.
All right. We have spoken with Mr. Gloria. I think you said that was the only person you were going to call, Ms. Miller?
That's correct, Your Honor.
And Mr. Zunino, your first witness.
Your Honor, I would like to call Wayne Thorley.
Mr. Thorley, will you please raise your right hand?
You do solemnly swear the testimony you're about to give in the matter now pending before this court is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, Mr. Zunino.
Mr. Thorley, would you state your full name and spell it for us, please?
My name is Wayne Thorley. First name is spelled W-A-Y-N-E. Last name is spelled T as in Tom, H-O-R-L-E-Y.
And for whom are you currently employed?
I'm currently employed by the Nevada Legislative Council Bureau.
And did you recently take that position?
Yes, I recently started that job on October 19th.
And in what job were you employed prior to that?
Prior to assuming that role with the Legislative Council Bureau, I was the Deputy Secretary of State for Elections with the Nevada Secretary of State's office.
And when did you assume that role?
In October 21st, 2015.
And were you with the Office of the Secretary of State even prior to assuming the position as Elections Deputy?
I was. I joined the office on January 5th, 2015 as Deputy Secretary of State for Operations.
So tell me about your duties as the Elections Deputy. What do you do on a daily basis or a weekly basis?
As Elections Deputy, I was responsible for overseeing the administration of all elections for public office in the state of Nevada, as well as ensuring compliance with all federal and state election laws. From the Secretary of State's office, we do a lot of administrative work when it comes to elections. The hands-on election administration work is done by the counties.
So tell me about your interaction with the county clerks and the county registrars. How frequently do you interact with them, say during an election or election season?
During an election season, we have weekly calls with all the counties that are standing calls, and then one-off calls with the counties, particularly the large counties. I speak to them on a daily basis nearly.
Do you provide training to the counties?
We do provide training to the counties at various times throughout the year.
Do you attend, say, conferences with county election workers, county personnel?
Yes.
Let me ask you about, there's a statute that's the subject of, there are many subjects here at issue, but one is the statute that requires counties to submit an observation plan to the Secretary of State for approval by April 15th. Are you aware of that statute?
Yes.
Okay. And tell me, typically, how do you process these plans? How are they submitted to you? Walk me through that, if you would.
These plans are generally submitted by email to the Secretary of State's office from the counties. The plan to accommodate observers is one of about half a dozen plans that each county is required to submit to the Secretary of State's office every election cycle. There is a tracking spreadsheet that we use to monitor which counties have submitted which plans and which date.
For this election, did Clark County timely submit a plan, an observer plan?
They did not.
Did you ask them to follow up, or how did you finally convince them to submit a plan?
On October 19th, I believe it was, reached out to Clark County via phone call to Mr. Joe Gloria, letting him know that the plan had not been received. He at that time indicated that the plan would be sent to us the next day. on October 20th, and we did in fact receive the plan on October 20th.
In the course of performing your duties as elections deputy, do you have an opportunity to tour the polling locations and the election facilities in the various counties?
Yes.
Okay, and as a general rule, are you familiar with the observation plan in each of the counties?
Yes.
And is there significant variance typically from one county to the next?
No.
So I have attached what I marked as Exhibit A to my answering brief. And I believe you have a copy of that, and I've supplied that to counsel, co-counsel, and opposing counsel. Wayne, do you recognize this letter?
Yes, I do.
How do you recognize it?
This is a letter from the Secretary of State's office to Mr. Gloria, acknowledging receipt of his plan to accommodate observers and providing a suggestion for consideration of adding to the plan.
Were you involved in or privy to the circumstances surrounding the drafting of that letter?
Yes.
And explain that to me. Why is it that you're still assisting the Secretary of State if you've moved on and you're working now for the Legislative Council Bureau?
Sure. Obviously all elections are important. This election is no different. Very important election. It's obviously a unique election in that we are doing a mostly vote by mail election statewide, and so I've offered my experience and expertise to the Secretary of State to help assist through this election.
So you will be assisting the Secretary of State's office through Election Day, is that correct?
That is correct.
Is it fair to say that you're effectively performing two jobs at the moment?
Yes, it very much feels like that too.
Okay. Let me take you back to the letter then, which is marked as Exhibit 8 for identification. Again, what were you privy to the circumstances surrounding the drafting of this letter?
The letter that is Exhibit 8.
It's 8 now. It's been marked 8 for the court's purposes. It's A on my brief that you have in front of you.
Yeah. To answer your question, yes.
Can you tell me, is there a reason why you or the Secretary did not use the term approve when you issued this letter?
We have, historically, we have never formally approved the county plans, whether it's plan for observers or some of the other statutorily required plans, by formally sending a response to the counties indicating that the plans are approved. Our past practice has been to, if there is an issue or an objection filed, we would let the county know, but otherwise approval is implied by our office.
With respect to Exhibit 8, do you consider that to be the equivalent of an approval by your office?
Yes.
Your Honor, I would move to admit Exhibit A at this point.
Mr. Binnall?
We have no objection.
No objection, Your Honor.
Ms. Miller?
No objection, Your Honor.
Mr. Devaney?
No objection, Your Honor.
Exhibit 8 is admitted.
So Wayne, I've also given you the copies of the observation plans that were submitted by the other counties. That's Exhibit B to my answering brief. but it will be marked, and I would request that it be marked, Your Honor, as Exhibit 9 for identification. And there's 17 county plans there. Each is about 2 pages.
It will be marked as Exhibit 9 for identification.
Okay. Wayne, have you had an opportunity to review those documents?
Yes,
And what are they?
they are the plans from the 17 counties in Nevada to accommodate observers.
And did you, I suppose with the exception of the Clark County plan, did you formally approve any of those plans for this election?
We did not formally approve any of the plans by responding to the county with an approval.
Okay. Do you note any kind of significant variance between those plans from one to the other?
No, most of the plans are pretty similar between county and also fairly similar from election year to election year.
I did note, and someone brought this to my attention, that Washoe County is streaming the counting of ballots. Is that your understanding as well?
Yes.
Was that in the plan, to your knowledge, the Washoe County written plan that they submitted?
I do not believe it was in the plan.
Okay. To your knowledge, is Washoe County using their own cameras, or are they using somebody else's cameras?
To my knowledge, they are using their own cameras.
Okay. Your Honor, I would request that Exhibit 9 be admitted. This is just for context, so you can compare the Clark County plan to the other plans.
Mr. Binnall or Mr. Hardy?
No objection, Your Honor.
Ms. Miller?
No objection, Your Honor.
Mr. Devaney?
No objection.
Exhibit 9 is admitted.
So there is, I'm trying to identify what exhibit it is. It's a spreadsheet. I think it's Exhibit 4 that deals with signature cure. And Wayne, I at the beginning of this hearing, I emailed you a copy of that. Do you have that in front of you?
Yes, I do.
So when maybe you can just give some explanation or provide a summary of what this document is, so we know what it is and what it signifies. Can you tell us what that is?
Certainly. This is a document that is produced by the Secretary of State's office. We update it at least once daily, sometimes more than once daily. The information on this document comes directly from the counties. We ask the counties to report the numbers to us, and then we simply input the numbers into the document. This specific document tracks signature cure information. By signature cure, we mean ballots, mail ballots that have been flagged as either having a missing signature on the ballot return envelope, or a signature on the ballot return envelope that does not match the signature on file for that voter. The far right section labeled total returned mail ballots that needed a signature cure. That is a running total by county of all ballots that were flagged for signature cure. The middle section titled total signatures successfully cured as a running total, again by county, of ballots that were successfully cured. And then the far left section titled current mail ballots needing signature cures are ballots outstanding by county that need a cure, a signature cure, I should say.
So let me ask you about the first column. Would the first column typically capture ballots that were or signatures that were submitted for for October 27th, would that be typically 1 day's worth of ballots?
It's cumulative, and so this document is dated October 27th at 10:34 a.m. This is cumulative information as of that date.
So this represents all the ballots that still haven't been cured as of October 27th, right?
Correct. The far left section represents all the ballots that still haven't been cured.
Okay, so let me ask you about the last section that indicates total return mail ballots that needed a signature cure. The percent of ballots, there's a column that's labeled percent of ballots returned. What does that mean exactly? Does that equate to a rejection rate?
To calculate percent of ballots returned, we take the total ballots needing signature cures, which is the column just to the left of that, as the numerator. The denominator is the number of ballots returned, which is the number of mail ballots that have been received by the county to date. So a simple calculation would be if 10 ballots needed to be cured and 100 ballots were received, then that percentage of ballots returned would be 10%.
And is that then indicative of the number of ballots that have been rejected for a signature mismatch or lack of signature?
Yes.
And that's by county, right? County by county?
Correct. And there's also a statewide number also that sums up the total for all the counties.
So let me ask you about the Clark County. The Clark County column, does this indicate that roughly 1.35% of ballots have been rejected for lack of signature or for a signature mismatch?
That is correct.
And is that more or less consistent with the rate of rejection in the other counties, according to this?
Yes.
Are there any counties here that you would kind of describe as outliers in terms of an unusually high rejection rate or an unusually low rejection rate?
I would describe Churchill County as having an unusually high rejection rate. I would use the term outlier to describe Churchill County.
Okay. What about Lincoln County? I think that's just because they have so few ballots, right?
Yeah, some of the small counties, the percentages I think suffer from just such a small number of ballots going into the calculation that even small changes in those numbers can really have large effects on the percentage.
So let me ask you about Washoe County. Does this indicate that the rate of rejection in Washoe County is roughly 0.69% or exactly 6.69%?
Yes.
Okay. So that's actually lower than Clark County, correct?
Correct. The rejection rate for signature issues in Washoe County is lower than it is in Clark County.
So that means they're accepting more ballots in Washoe County than in Clark County, correct?
They aren't rejecting as many ballots for signature issues.
Okay. Let me ask you what you were you involved in distributing federal funds prior to the primary election this year?
Yes.
Okay, and what was the source of the funds? Was that the CARES Act?
Correct. Nevada received approximately $4.5 million from the CARES Act that were specifically earmarked towards the administration of elections. And the direction was to use it for purchases to assist with running elections during a pandemic.
Did you distribute the money to the counties on a pro rata basis, or how did you do that?
It was on a reimbursement. I should start over. It varies. Primarily, it was on a reimbursement basis. The largest chunk of that money went to counties for the printing and mailing of ballots. But it was based on a reimbursement request primarily from the counties. Other purchases were direct purchases.
Were the funds used to acquire scanning equipment for the counties?
Yes, we directly purchased mail ballot scanners, ballot on demand printers, and ballot adjudication stations directly from the voting system vendor for the counties to use for the elections this year.
Tell me about the scanners. What did they actually count the ballots, or what do they do?
They are digital scanners. It varies somewhat by county what scanner they're using, depending on the voting system that the county is using. But they're digital scanners. They are not, to my knowledge, tabulators. There is a different component in the system that actually tabulates the results, but they are reading votes off that.
So the scanners create a digital image that the tabulators in turn use to count the vote?
That's my understanding.
Okay. And do all the counties have this equipment, to your knowledge?
Yes, they have. They don't all have the same scanning and tabulation equipment. They're from different vendors or different models, but they all have equipment that does that job.
Do any counties, to your knowledge, have to hand count ballots?
No counties, to my knowledge, hand count ballots.
Let me ask you about the ballots themselves. Is there any information on that ballot that would allow somebody to identify the voter on the ballot itself?
Not to my knowledge.
There isn't a barcode or anything that.
There may be barcodes or other information on the ballot to identify precinct style, or I should say ballot style, precinct number, things of that nature. But my understanding is there's nothing identifiable on the ballot that would link that ballot back to a specific voter.
So let me ask you about ballot extraction. Are you familiar with the ballot extraction process generally?
By ballot extraction, do you mean the removal of the ballot from the ballot return envelope?
Yeah, when it's received and it's removed from the envelope.
I'm familiar to the extent that I have observed the counties performing that.
And typically, in your estimation, during this ballot extraction, how do the county election workers kind of protect ballot secrecy?
The ballot is removed from the envelope. The voter themselves have an opportunity to insert their ballot into a secrecy sleeve. They're not required to do that, but a secrecy sleeve is provided to all voters. When the ballot is removed from the envelope, if the ballot is in that secrecy sleeve, it protects that information from the worker there. The workers also are they're not looking to see how voters voted. They're simply pulling ballots out of envelopes and then separating them into different piles.
Is there a reason why an election worker would need to look at the ballot at that point in time?
When it's pulled out,
Yeah.
yeah, if the ballot is damaged, or is otherwise has correction fluid on it, is torn, stained, anything that might prevent the ballot from running through the scanner correctly and might actually damage the scanner, would be pulled out so that it doesn't go through the scanner. So there is a reason for the person to review the ballot, not for who the person voted for, but to make sure the ballot itself is not, I don't know, compromised isn't the right word, but isn't damaged.
They're checking to see whether it can be fed through the scanner, correct?
Correct.
Let me ask you about the physical voting machines. Are you familiar with the mechanical voting machines that are used in the state of Nevada?
Yes.
And how did you acquire that familiarity with the voting machines?
Through my work with the Secretary of State's office, I've been involved in multiple voting machine certification processes where we have certified voting equipment, and then through training with the counties and just general experience working in elections, I've become familiar with how they operate.
Let me ask you, when a person uses a mechanical voting machine and they pull the lever or they push the button, what have you, is the vote separated from the voter's identity at that point?
Yes, it is.
And how does that work mechanically? Can you explain that, or maybe it's more complicated?
The votes are stored on internal memory device on the voting machine. It's stored actually in multiple locations on the actual hard drive of the voting machine, but also on a removable storage device. But it is just stored as just raw vote data. It's not stored as a vote coming from a specific voter.
So there's no way to trace the vote back to the voter once it's cast. Is that accurate?
That is accurate.
Let me ask you about the Agilis machine or the Agilis machine in Clark County. Was your office involved in the procurement of that machine?
We were involved with the financing. We provided money for the county to purchase the Agilis machine, but we were not involved in the actual procurement of it, the contracting with the vendor and things like that. We simply provided money to the county to purchase it.
Was that CARES Act money?
Yes, this was part of the CARES Act money that I previously described.
To your knowledge, did other counties procure or acquire the same or similar equipment?
Washoe County has similar equipment. It's a mail sorter. It's not the same brand or from the same manufacturer. And it also does not perform signature verification. So it only sorts mail, sorts ballots, however the county wants them to be sorted.
So is it true then that Clark County is the only county that has the ability to verify signatures using a machine?
I don't know if it's true to say they're the ones that have the ability. I think Washoe County has the ability to do it with this machine, but Washoe County is not using the machine for that purpose for this election. It is fair to say Clark County is the only county that is using signature verification software.
Do you have a sense as to relative workloads from one county to the next? You know, have you been able to kind of evaluate that and get a sense as to how the workloads of election workers compare from one county to the next?
Yes.
And how, what is the workload, say for example, in Clark County versus some of the other counties?
Clark County has over 70% of the active registered voters in the state of Nevada. So they have a much higher workload when it comes to all aspects of election administration, the recruitment and training of poll workers, the identification and procurement of polling locations, the printing and mailing of ballots is all done on a scale that is much, much larger than any other county in Nevada.
Okay. Thank you, Wayne. I have no further questions.
Mr. Devaney?
Your Honor, I'll be very brief. Good afternoon, Mr. Thorley. I'm John Devaney. And just wanted to ask you, could you tell us what the canvassing deadline is and what the significance of that date is?
The canvassing deadline for the counties is 13 days after the general election, which this year is November 16th. I believe it's a Monday. That is the date by which the counties have to conduct a public meeting of the county commissioners to canvass, which is another way of just saying certify the election results. At that time, the election results in that county become official.
And what are the consequences if that deadline is not met?
There are a number of downstream effects that would have. There is a Supreme Court canvass on the fourth Tuesday in November, which is November 24th this year. That canvass is to certify the statewide or multi-county contests. So these are the contests that are voted on in more than one county. A delay in a county canvass could have an effect on our ability to conduct the Supreme Court canvass on November 24th. There are periods of time for an individual to challenge an election or to submit a request for a recount, and a delay in the canvass would be a delay in the when those could be requested, which again could have an effect on the Supreme Court canvass, and then ultimately on the presidential electors meeting, which is held on, which will be held on December 14th this year.
Thank you. In your examination earlier, you were asked about signature rejection rates for this general election. And I'm just wondering, do you have in your mind a comparison of the rejection rates that you're seeing for this election versus for more recent elections such as 2018 and 2016, and whether the current rejection rates are in the same ballpark?
I don't. We did not track at the state level rejection rates for mail ballots in prior election years, simply because voting by mail made up such a small percentage of all the ballots cast. So I don't have a basis to compare the rejection rates this general election to prior general elections.
And are you able to say what percentage of votes are likely to be cast by mail this year?
I would be guessing. I can't say with any certainty what percentage of votes would be cast by mail. We do have, lots of votes in already, and many people are voting by mail, but many people are also voting in person. I don't know what that mix will end up being.
Fair enough. Okay, thank you very much. No further questions.
Council, I have this is the time set on our calendar every week for involuntary mental health evaluations. I have one now. So before Mr. Hardy or Mr. Binnall, we're going to take a break. Those can take from about 10 to 30 minutes. So stay close, and as soon as I'm done, I will be back. We'll be in recess until then.
Thank you, Your Honor.
Thank you.
I make a finding that paternity has been established.
Give us the potential to introduce children.
We're here for the court's order to show cause.
Okay, so that takes care of one motion.
Maybe somebody can tell me what the status is.
Any preliminary issues we need to take care of?
We'll make sure that she's put on house arrest.
As you know, the Supreme Court has
We are back on 20 OC 142, Kraus versus Sagavsky. Counsel are present. I apologize for the delay. That's not an optional hearing. So we were to Mr. Hardy or Mr. Binnall, cross-examine Mr. Thorley.
Thank you, Your Honor. And Mr. Thorley, my name is Jesse Binnall, and I represent petitioners. Mr. Thorley, you're aware of a letter that was sent on October 22nd by the Secretary of State to Mr. Gloria, correct?
Yes.
And in fact, that letter was written after the plan was received on the 21st of October, the day before, correct?
That is correct.
Okay. And in fact, then the reason that that plan was submitted is the day before that, on the 20th, the Secretary of State's office asked them what the status of that plan was, right?
Correct. It was either the 19th or the 20th. I don't recall the exact date, but it was around that time.
And was that prompted by a letter that you received from Brian Hardy on behalf of the Trump campaign and the Nevada Republican Party on the 20th of October?
Yes.
And so 20th of October, you receive a letter from Mr. Hardy. Immediately reach out to Clark County. They turn around an observation plan to send to you the next day. And then the very next day after that, on the 22nd, Exhibit 8, that other letter is sent to them, correct?
That is a correct timeline.
Okay. Now, that letter, which is Exhibit 8, do you have that in front of you?
Yes,
And this is the letter from the Secretary of State to Mr. Gloria, correct?
yes,
Nowhere does the word approve can be found anywhere in this letter, right?
that is correct.
Matter of fact, in the Ray line of that letter, it says revision of observation plan. Isn't that right?
That is correct. It says revision of observation plan.
Okay. Did Clark County ever give you a revised plan?
Not to my knowledge.
And it's your position, it sounds like today, that the Secretary of State's office believes that because the letter didn't outright disapprove the plan, that it implicitly approved the plan. Is that your position?
Yes, it is.
All right. Are you aware of NRS 293B.354?
Yes,
And that's the statute that requires that plans be submitted to your office, correct?
yes, that is that statute.
All right. Is there anywhere in that statute where we can find language that allows the Secretary of State to use silence as acquiescence to approve plans?
I believe the language in the statute is submit to the Secretary of State for, I believe it's review and approval. I don't have it right in front of me.
I understand. If I told you it said, submit to the Secretary of State for approval a written plan for the accommodations of members of the general public who observe the delivery, counting, handling, and processing of ballots at a polling place, receiving center, or central counting place, would that sound right to you?
That sounds right to me.
All right. Does the Secretary of State's office have a regulation that is promulgated, that is sent out, saying that it can approve by silence through acquiescence?
There is no regulation promulgated by the Secretary of State that says that.
How about a written policy? Any written policies on that?
No, I'm not aware of a written policy that says what you mentioned.
Okay. Is there anything that you know of, either a statute, policy, or regulation, that changes the duties found in 293B.354?
What do you mean by changes the duty?
Is there anything that modifies that you're aware of?
No.
Now, every other county other than Clark County sent in their responses and sent them in timely, right?
That is my understanding, yes.
And by timely, the statute requires April 15th, deadline of April 15th, right?
That is correct.
And a lot of us are familiar with April 15th deadline by other government bodies. That seems to be a date that comes up, doesn't it? It's tax day, right?
Was that a question? Yes, April 15th is tax day.
But Clark County, they didn't get their filing in on April 15th, did they?
They did not.
Matter of fact, it was over 6 months later on October 21st, half a year later, that they finally submitted a plan, right?
That is correct.
All right. Sir, are you familiar with the Voters' Bill of Rights in Nevada?
Yes,
And did you know that that's codified at NRS 293.2546?
I don't know the statutory reference offhand, but that sounds right.
Okay. And do you know if part of that was, if number 10 in that bill provides that voters have a right, quote, to have a uniform statewide standard for counting and recounting all votes accurately?
Yes, I'm aware of that.
Okay. Thank you, sir. Those are the questions I have.
Mr. Zunino, redirect.
Just a few questions, Your Honor. Mr. Thorley, in your position as elections deputy, do you have to read and interpret statutes?
Yes,
Okay, and do you have to read and interpret regulations?
yes,
Do you have to, on occasion, explain those to the county election personnel?
yes.
Let me ask you, do you have an opinion as to whether Clark County's observation plan is legally sufficient?
I believe Clark County's observation plan is legally sufficient.
Thank you.
Mr. Devaney.
Just one follow-up. Thank you, Your Honor. Mr. Thorley, following up on counsel's last question, when the letter was sent from the Secretary of State in response to the plan, at the time of the letter, did the Secretary of State's office find the plan to be acceptable and in compliance with Nevada law?
Yes.
Thank you. No further questions, Your Honor.
Mr. Law, you recross.
Briefly, just on that issue, where in the letter sent on October 22nd does it say, sir, that you found their plan acceptable?
I'm sorry, can you repeat the question? You cut out right at the end.
But where in the letter sent by the Secretary of State to Joe Gloria on October 22nd does it say that the plan is acceptable?
It does not say in those words that the plan is accepted. It's our position that by not saying the plan was rejected, that it was implicitly accepted.
Do you have any documents or communications with Mr. Gloria saying it's acceptable?
No.
Thank you, sir.
Thank you, Mr. Thorley. Mr. Zunino, your next
Nothing.
witness.
Your Honor, I have no further witnesses. No additional witnesses.
And I believe, Ms. Miller, you told me you did not have any, and Mr. Devaney, you do not have any?
That's correct, Your Honor.
You prepared then to present a closing argument, Mr. Hardy or Mr. Binnall?
Yes, sir. Your Honor, in his testimony today, Mr. Gloria said that the most important thing in an election is integrity, the integrity of the election. The evidence today, what's come in, has shown a problem with transparency that seriously threatens that integrity that he thinks is so important of this entire election. The questions that we have, the transparency that is being ignored, that is being blocked completely by Mr. Gloria's office and by the Secretary of State by not acting to ensure that there's transparency, threatens the legitimacy of this election. If we can't find some way to ensure that transparency and to ensure accountability. The hallmark of our democratic republic is a voting rights system that allows all eligible voters to vote once. To make sure that there's not votes, that honest Nevadans, honest Americans' votes aren't diluted by fraudulent votes, by improper votes. People that might think that because passions are running high and they're so emotional about this election that they want to have their say several times, or maybe they want to have their say on behalf of relatives who have passed away. The way that we can guard against that, one of the most important ways that we can guard against that, is strong observation procedures to make sure that our election officials are using reasonable procedures to stop any attempts by bad actors to improperly influence this election through improper means. Sunshine is the greatest of disinfectants. But that's not what we have from Clark County right now. That's not what the evidence today showed. What the evidence showed is efforts taken by some officials to block transparency, block observers in the dead of night, literally. And we've seen the actions to make that don't allow voters to know that their vote isn't being diluted, because when you have ballots that are out of their envelopes, when they're most in the point where they are most susceptible to bad acts, there is not a transparency system in place right now in Clark County that could guard against the fraud that could happen. And that's not to say that most election officials are fraudulent. Most of these people undoubtedly are good people, people that wouldn't engage in fraud. But part of our country and part of our system is not having to blindly rely on officials to blindly say, we're going to trust you. There's always that American spirit that we need some sort of checks and balances, and we need some sort of verification. And that's something that we've spread through the entire world. And we've told people that we need to have voter accountability services. If we're going to have some sort of democratic system, there needs to be some sort of accountability to make sure that bad actors don't steal elections. That's what we need. That's all we're asking for here, is accountability and observation. Not blind trust. Not situations where some people in the heat of an election, an emotional election where people have very strongly held beliefs, might be tempted. And that's the other problem. Right now, when you have all these times that we've seen where ballots are unguarded, where people are in closed doors with pens, writing on ballots, all these times that's out there where people might be tempted and they might give in to temptation. That's why observation is so important. That's why it's such a bedrock principle for what we stand for as a country. Our first count that we talk about is that right to observation. And Mr. Gloria, in his testimony, admitted that there is numerous stages of the processing of ballots where there is not a meaningful opportunity to observe. And there is no doubt that many of the reasons that he's limiting this right now are with understandable intentions. We do have COVID. That is something that we have to deal with right now. We need to make sure that we protect the health of people. but that we don't do that at the expense of transparency in our election system. We don't sacrifice our transparency. We find ways to protect people's health and still protect the rights of Nevadans to observe. And we can do that. We can have reasonable restrictions on poll observers. We can say that they've got to wear medical grade PPE, N95s. We can say that they have to wear face shields. We can say that they have any number of, some distance requirements, as long as those distance requirements still allow meaningful observation of this process. But it has to be a meaningful opportunity to observe, because you have heard evidence from our witnesses today about people taking those ballots behind the closed doors, where you have the ballot that is at the counting board's table that needs duplication. A runner who's not a member of the counting board, doesn't have to be bipartisan, takes that ballot, puts it in the green manila folder, then takes it into that room, the vault room, MB vault room in Greystone, and it often closes the door, is alone often with those ballots for some amount of time, often with a pen. There's been testimony that people have written on the ballot during that time. And then it's taken to duplicators. And the testimony is that the duplicators are out of sight of the observers. These are people that are actually serving as a proxy for the voter and marking the ballot on behalf of the voter. This is a huge responsibility we've given these people, and they're not subject to any transparency. They're not subject to observers. So all we're asking for is some meaningful way to observe this process. Some meaningful way also to observe the signature matching process. And you heard testimony from Ms. Diaz, who says that she sat there and watched signatures. Oftentimes it didn't look like one signature looking like the one it's being compared against. And that they were passing through it and approving it. And in one case, it was rather egregious, and she tried to allow a challenge. And Mr. Gloria said there were no challenges, but you've heard just today from one of our witnesses tried to lodge a challenge and wasn't allowed. There was no process to do that. There needs to be some way to make sure that when people walk into a voting booth and you have poll observers, especially if they're poll observers who are local, they go, oh, okay, I see these people. I know who they are. These are my neighbors. There's other ways to identify them. All these ballot envelopes, they all look alike. There's no other way other than signatures. They're all looking like this. They all look alike. There's no way other than observation through the signature matching process that you can get some sort of accountability for that. You heard the testimony of Ms. Lawrence and Mr. Suarez today. Testimony where they explained to the court how Ms. Lawrence went for her shift just 2 nights ago to observe the proceedings and was told time and time again, and she pushed. She said very clearly that she pushed. And they were told nothing else was going to happen, that they had ceased operations for the day. 1 hour later, Mr. Suarez shows up for his shift that starts at 8 o'clock, and the Liberty Room is going. Or the Liberty or the Freedom Room. One of the signature match rooms is going. After they were specifically asked an hour earlier whether operations were continuing in that room. They said no. Then an hour later, there's operations going on in that room. In the dead of night, outside the presence of observers, without accountability. The next thing that we talk about, Your Honor, is ballot secrecy. This is a pretty simple one. This should not be hard to fix. They have a process that is not required by statute, where if they are going to reject a ballot because somebody signed the ballot, they go and they find that ballot again, that they find the envelope again, put the ballot back in the envelope. The statute does not require that. It just has to be put in an envelope. In doing that, the only way, and this is the testimony of Mr. Gloria, at least that there's nothing to the contrary, is to keep the ballots in sequential order so that it is then possible, after reviewing the ballots, after seeing who people voted for, that privacy that we all take for granted so much, we have nothing to ensure that a counting board member can't go back for anyone, not just someone whose vote is being rejected, but by anyone, in sequential order to see who cast that particular ballot, to see if it's one of their friends and neighbors who said they'd vote one way publicly but another way privately, which is their right. You can't do it that way. What you have to do is, once you separate the ballot and the envelope, they never again shall meet. At that point, those items have to be separated in such a way that we ensure the secrecy of the ballot. The next item that we have, Your Honor, is the equal protection challenge. The courts have been very clear. You cannot have multiple classes of voters in a state. You can't take and treat one group of voters differently than another in a material way. And the Ninth Circuit, in a case really not dealt with in the briefs of the petitioners, I'm sorry, the respondents, has said that challenge procedures raise the equal protection issue. The law on this is clear, that you do have a right, an equal protection right, where one group of people is not subject to challenge, another group of people is subject to challenge. It doesn't matter how little your vote might be diluted. At that point, any debasement at all, just a trifle, is enough for equal protection to lie. And that is something that in our papers, we cited I believe it's the Kemp case, very recent, out of I think the 11th Circuit, Georgia in the 11th Circuit, that dealt with a very similar issue as well. Now, they say they have a little bit of a moving target when they say that there is a right to challenge. First, they pointed to a statute that was very clearly not on point, because the statute says, yeah, sure, you can challenge a statute that I think pretty clearly is for voter registration. You can challenge up to 25 days before an election. They're not even processing at that point. I mean, at that point, you might as well just tell people to jump over the moon to challenge. You can't have some sort of, that requires some sort of impossible ability to see in the future for there to be a meaningful challenge. So the next thing that they come up with is, oh, we do allow people to challenge in Clark County, when now you have seen the documents that tell observers you can't challenge. So to say that they're expected to challenge when they're told that they can't, they have to sign an agreement saying that they won't challenge, is certainly not reasonable. Right now, the facts and the evidence are very clear that there is not an opportunity to challenge the mail-in votes. When you can challenge people who vote in person, you cannot challenge people who vote by mail. That's an equal protection violation, and that can't happen. There's also the fact that Nevada has the Voter Bill of Rights that says that you've got to treat people the same. You have to have the same system for counting and recounting ballots. Finally, Your Honor, we have the issue with the Agilis machine. The biggest problem with the Agilis machine is it's simply not authorized by statute. We briefed this in some detail, and I'm not going to waste the court's time with going over the exact arguments that we already briefed. But the important point, the very important point here, is the legislature has said There's plenty of things you can use machines for. For instance, we're not saying it's a problem that they scan the ballots through the machine in order to take a scan of the signatures so the people in the Liberty and Freedom Room can, it can assist them with their matching. But they can't. There is no method in the statute for them to use the machine to authenticate the signatures using artificial intelligence. Especially when Mr. Gloria testifies that they're using DMV signatures as one of the items that they are to look for in this machine. Signatures that are scanned at less than 200 DPI, 200 dots per inch. And yet Mr. Gloria testified that the manufacturers told him that they need scans of more than 200 in order to have a good match. Otherwise, what you're looking at is trying to take, if I took a really nice picture with my iPhone, nice, crisp, and clear, and then I took another picture of the same person or some person that was out of focus using old technology from a distance, and then holding them up and trying to determine if it was the same person. The manufacturer says for a reason that it has to be more than 200 DPI, more than 200 dots per inch, but they are ignoring that requirement. They are using the scans from less than 200 DPI from the DMV in order to do these matches. And that was the testimony of Mr. Glory. It's something that's not authorized by statute. It's something that they're not even following the directions for the machine that they're given. It's something where any training or training, any machine learning that's done in order to make sure that the machine is working right and is doing right, they haven't even gone into the detail needed in order for the court to know that that is legitimate. They haven't been able to show that they have a good reason for ignoring the laws of Nevada that require them to have humans, people, match those signatures rather than a machine using poor quality images in such a way that might allow forgeries to get through, might allow these false positives. These are not heavy lifts. Yes, it might take a little bit longer, but only 30%, for instance, of the votes are making it through this machine anyhow. It is more important that we get this right than we get it quick. It's more important that we have an election result in Nevada that we can rely upon, that we know isn't subject to fraud, than we get it done quick. Transparency is key in our country. We ask that you grant the petition. And I reserve the rest of my time for rebuttal.
Would you please tell me specifically what it is you want me to order?
Yes, sir. We want you to order the Secretary of State and Clark County, first of all, to allow observers meaningful observation, which is right in the definition of the statute of meaningful, no matter what you look at, whether it's Webster's or Black's or whatever it is, observation has to be meaningful. At every stage, there's a ballot open and there's a employee that is dealing with that ballot, there has to be some form of observation. That is something that is required by statute. There has to be that observation ability. You can't have things done behind closed doors. We are open for any solutions.
And when you say observation at every stage, sorry, when you say observation at every stage, can you be a little more specific? Do they need to be within a certain distance? Do they need to be able to see certain information?
Yeah, like it has to be such that if there is data that needs to be challenged, they can see that data. So for instance, in the signature room, they have to be able to see the signatures that are being matched. They don't have to necessarily see the other data that might be on the screen, although, you know, the evidence is you're sitting people close enough to some terminals, not others, that they can see the screens anyhow, that you can be able to tell whether those signatures actually match. And so I think if the court enters grants mandamus, gives mandate that they have to provide for meaningful observations so that, for instance, you can see the signatures, that you can see all the stations in Flamingo, that you can, including the auditing station, including the duplication stage, including some way to have monitoring of the ballot room. And let me just say that the ballot room, the MB vault, that's the easiest of all. You just need a security camera. You need some sort of camera in there where people can view it to make sure that people aren't engaging in bad acts in that room. Same with the office. If people are going to bring ballots to an office, you have to have some kind of monitoring of that to make sure that, you know, whether it's an office, a vault, or a dark closet, ballots don't go anywhere when they're open without some accountability. For the secrecy issue, it again is very simple. The mandate here is just that they cease stacking envelopes after they're separated sequentially, and to make it impossible for them to be to be brought back together again, so that somebody can find that envelope from a ballot that's been open. For equal protection, there has to be a challenge procedure. The challenge procedure that we suggest is that our observers can challenge the authentication of the ballots in such a way that, you know, they can do it orally first and then in writing in such a way where a challenge has to be adjudicated by Mr. Gloria or any of the other officials where you would have that challenge. That challenge, that equal protection, you know, count is important to make sure that there is that challenge procedure available. And for the Agilis machine, that the Agilis machine not be used for signature matching. They can use it for other things, but they cannot use it for signature matching. And that's what we're asking the court to order. Does the court have any other questions on that?
No, I don't. Thank you.
Thank you, Your Honor.
Mr. Zunino.
Okay, I do not find a statute in Nevada that authorizes observers to follow the ballot from beginning to end, from the time that it's received to the time that it's counted, through every stage, through every hallway, through every room. That's not what the statute requires. The statute talks about observation of the counting of ballots, and they've taken that and they've turned it into something that it's not. So the, you know, and that's not to say they don't have good policy arguments, right? They might have an argument about how we've transitioned to vote by mail, and now we need more robust kind of anti-fraud provisions. We need more transparency. Those are good arguments to make to the legislature. Those are good, arguments that a lobbyist would make to the legislature, or that the public would make to the legislature. And I've been arguing this all along the way. You know, beginning in March, we've been arguing about standing with various parties, including previously with the Trump campaign. And the bottom line is that fears about voter fraud, the fear that mail-in kind of opens the door to fraud, is not a ground for standing. There's no injury. It's an abstraction. We're talking right at this point. If we're concerned about voter fraud, we're talking about a potential injury that everybody suffers from. The entire electorate suffers from voter fraud if and when it occurs, and it hasn't occurred yet. But if it were to occur, everybody suffers. The entire electorate has their votes diluted in some respect, and the federal courts that have addressed this, that are, you know, the decisions are cited in my brief, have said, that's not a particularized injury. That is an abstract general injury. It's an injury to everyone, assuming it occurs. It can't form the basis for standing. And I realize that the standing doctrine in Nevada is a little bit different, but by and large, there's enough consistency there that I think any judge should conclude under these circumstances that the petitioners have not demonstrated have not demonstrated a specific and particularized injury. It's just not enough to say we're worried about voter fraud. Judge, we need you to fix it. We need you to amend the elections code for us. We need you to impose duties upon the county registrar that aren't found anywhere in the statutes or the regulations. And there's a case on point that I unfortunately didn't cite in my my brief, and I didn't see anybody else cite it either. But it's TAM versus Colton, or TAM versus Board of Regents rather, 94 Nevada 453, and the Nevada Supreme Court here basically articulates at the very end of the opinion an abstention doctrine. They say, and I'll just be brief. They say, we conclude, therefore, that the procedural setting and the time constraints involved in this case render impossible a proper assessment of the appellate's claim and the imposition of any acceptable remedy if he should prove ultimately successful. We shall therefore affirm the district court's denial of the petition for writ of mandamus. So in that case, there was a dispute. It was during the election, and the court said, this strains the confidence of the court. What they're asking us to do is to go and craft a whole new set of statutes to deal with vote by mail, and to persuade us that you've addressed our concerns about voter fraud. That's just simply not something that the courts, are competent to do on the eve of an election. We could have a trial, and it could go 10 or 15 days, and we still wouldn't. I don't think anybody would be convinced that the Agilus machine, for example, has caused somebody an injury. What is the injury that's been caused by the use of the Agilus machine? And I recognize that, I think they have a good faith argument that the provisions of AB4 indicate that humans will view the signatures. Election workers will look at the signatures and make comparisons and decide whether they match or not. But what is the harm that the fact that they're using the Agilus machine to pre-screen roughly 30% of the signatures that we know are very precise matches, right? And we haven't heard any testimony to the effect that mismatches are creeping through and making their way into the batch of ballots that are counted. By and large, the use of the Agilus machine simply makes it easier for Joe Gloria and his staff to process the enormous amount of ballots that they're getting. And I think to eliminate their use of that machine arguably would handicap them in a way that would be detrimental to Clark County voters as opposed to the voters in some other county where the election workers don't face similar logistical challenges. So, all these equal protection arguments that they make cut both ways. You can argue that it hurts one group to the benefit of another group, and they always cut both ways. The argument about the challenge process, for example, they pointed out that there is a challenge process. There's a means or a way to challenge voters who vote in person. There is not, as a practical matter, an effective way to challenge voters who vote by mail. And that is more or less true. There is a statute that allows people to make a written challenge, 25, 30 days in advance of the election. So for example, if you thought that your neighbor was an imposter. He was pretending to be someone he was not. He was going to cast a vote. You could make a written challenge. If you thought that there was a non-resident or a foreign national that was planning to vote, you could make a written challenge to that person in accordance with these statutes and prevent potentially that person from casting a mail ballot. So there is a process in place for challenging, but as Mr. Binnall pointed out, it's not perfect. It's not a great system, but the reality is there's really no way to establish a challenge process for mail ballots because it would seriously compromise voter secrecy, ballot secrecy, which Mr. Binnall claims to be concerned about. Yet if we're challenging voters after they've already cast their votes, right, and that's effectively when you put your ballot in the mailbox, you're casting it. It's gone. It's done. It arrives at the county's facility. It's been cast, and now to make a challenge to that voter is problematic because you've got to open it and look and see how they voted. That as Mr. Binnall suggested in his opening, we want to be able to follow that ballot around and keep that signature envelope married up with the ballot so we can determine, who fraudulently cast that ballot. Unfortunately, the system just doesn't work that way, and it can't work that way. There's just no way. There are too many competing concerns. There's ballot secrecy versus, that's competing against other concerns about, voter fraud. And the bottom line is with regard to this issue that there's no way to challenge mail-in ballots. I think once again, that is an abstract injury, and assuming it is an injury, it's an injury that everybody suffers. I mean, the entire electorate has that problem. If I want to challenge somebody who is planning to cast a mail-in ballot, I'm injured. If MaryAnn wants to challenge somebody who's going to cast a mail-in ballot, that's an injury. That's an injury to all of us, right? It's not a concrete, particularized injury. Again, it's just a generalized concern about, well, our voting procedures are not sufficiently robust. We need more robust procedures. And again, that's a legislative problem. Take that to the legislature. It's not the proper subject of a lawsuit. So I think ultimately, I would concede that if there's a statute on point that says that observers are entitled to observe a certain part of the process, counting, for example, I think they have standing to enforce that statute. The statute exists for their benefit, right? And here we have a statute that says that people can observe counting. So I would concede that they have standing to enforce that statute, certainly. But here they are entitled to observe counting. I mean, that statute has been complied with. There's not an issue there with the observation that the county is doing, as far as I can tell, everything that they're required to do under the statutes. And the petitioners are suggesting that they have to do more, because the Constitution requires it, but they can't quite articulate why the Constitution requires that or why they have standing to enforce, or amend or change these kind of statutes on behalf of the electorate at large, which is effectively what they're doing. I mean, they don't explain why they don't explain why they have standing as Republicans, for example, to challenge this. Because fraud cuts both ways. They can't very well make that argument. They can't argue that they have standing as a discrete group of voters who favors a certain kind of agenda or position that these measures discriminate against them, because again, we're just speculating, and ultimately I think voter fraud cuts in all directions, and ultimately we all suffer if there's voter fraud. We all suffer vote dilution, but that's not grounds for a lawsuit. So that's my closing, Your Honor, and I would suggest once again that the abstention would be appropriate. If you choose to go that route, or if you choose to address these many arguments. I think they all all of these arguments come down in favor of the county and the state. So thank you.
Thank you. Ms. Miller?
Thank you, Your Honor. I would also reiterate that the petitioners have not established any statute that either the Secretary of State or the Registrar of Voters has violated that has caused them harm. And so they really can't prevail on their mandamus or their prohibition claims. All of the evidence that they have submitted today is speculative. They have not identified any error or any fraud that's taken place on behalf of any election voter. I think it just goes to show that Mr. Gloria went above and beyond what the statute allows to allow observation on all of the areas where the ballots themselves individually are being handled, so that there could be, if there's any, I think what one witness called sleight of hand going on, that they could look at that. But they want something more. They want to be able to lean over the shoulder of every worker and double check that worker's progress. And under the statutes that we have today, they have absolutely no right to do that. The legislature has given them that right. And it would be highly interfering with the process, especially when we've got separation requirements in place right now. We'd have a lot of difficulty recruiting or keeping workers if that was going to be the case by any court order. I'm also concerned with the concept that they have some equal protection right to challenge the signature of mail ballot voters. Under the statutory challenge rights that we have, either written or orally, neither one of them allow for challenge of a signature. So they're making that right up out of whole cloth. And further, we heard testimony today from several ballot election observers, but only one of them was a Clark County registered voter. And our challenge statutes require that to challenge someone, you've got to be a registered voter in that precinct. In Clark County, we have 1,150 precincts. So as a practical matter, whether you're talking a written challenge or an oral challenge out at our vote centers, it's unlikely that you're going to find a very significant number of ballots by that or votes that can be challenged by properly registered voters. And you heard the testimony of Mr. Kraus today, who is a registered voter in Clark County, that there wasn't anybody he intended to challenge. He didn't have anybody in mind. So he doesn't have any harm at all with respect to the challenge statutes. And there's no equal protection violation because everybody's in the same boat. They have, as it's pointed out, well, I think one of your witnesses today said that the ballot counting place is fine. He even referred to it as a fishbowl because everybody can get close and see exactly what those tabulation people are doing. But we have, to the extent that we have space, we have allowed observers in every area where individual ballots are handled. And the fact that a ballot is carried around occasionally in a green envelope because there might be some problem with them is not reason to condemn the whole system or to order the county at this late date to install a bunch of cameras that the statutes just don't require. And with regard to the Agilus machine, you weren't presented any evidence that the machine doesn't do anything than what it's intended to do, and that is to get the low-hanging fruit. Mr. Gloria did not testify that it reads the DMV vote signature captures that are less than 200 PSI or dots per inch. He says that they come in less than 200, and that might explain why only 30% of our signatures are being captured, because a lot of them do come from DMV, and the machine at the setting of 40, which is a conservative setting, doesn't capture those. I'd also like to draw attention to the fact that the Republican Party has known that we've been using this machine for a long time. They had a chance to talk to Mr. Gloria under oath in July. They've come in and visited him since that time, and they wait until we're in the middle literally in the middle of counting those ballots to ask us to stop. If we stop using that machine, we would have to go out and try to find additional election workers and train them. And it's, Mr. Gloria said, it's very unlikely that we'll meet our statutory deadlines if at this late date, the court comes in and orders us to change our process. I think that just goes to the balance of the equities, Your Honor. They have waited too long and not identified any statutes that we're violating to come in and ask this court to intervene. Thank you.
Thank you. Mr. Devaney?
Thank you, Your Honor, and I'll try not to be repetitive. The fundamental point that I would like to make, Your Honor, is going back to obviously the context, which is mandamus. And Your Honor is aware of the very high bar that one must get over to authorize a mandamus writ. It's truly extraordinary relief. Here, Your Honor, the petitioners are essentially asking you to create policy and sometimes to actually ignore statutes. And mandamus, of course, is the question is the election official refusing to take action that is required by statute? And there's no evidence to that effect at all. The evidence has been demonstrated that the counting of ballots, and that is what is required, has been permitted extensively. We did not hear testimony from observers that they're having difficulty watching the counting of ballots. They had complaints about not being able to see duplication or perhaps not seeing signatures clearly on computer screens. But none of that is required by statute. And in fact, as Ms. Miller just described, the Clark County officials, including Mr. Gloria, are allowing observation that goes well beyond vote counting. And sure, the petitioners would like more, but that's just simply not required by statute. And a couple of examples of what I'm describing. One is the Agilus machine itself. And there is a statute, Your Honor, that says for any affected election, the county or city clerk, as applicable, shall establish procedures for the processing and counting of mail ballots. The procedures may authorize mail ballots to be processed and counted by electronic means. That's AB Section 22. Petitioners entirely ignore that statutory provision and ask you to essentially legislate and say that for some reason electronic processing of ballots is prohibited, and it's not. And as Mr. Gloria testified, there are major cities in this country that have used Agilus or using it now. He has extensive experience in election machine technology, and as an election official, his decision and the county's decision to use that technology deserves deference and is hardly the subject for a mandamus writ. And Your Honor, as Ms. Miller said, the effect of requiring that the county stop using Agilus now would be very severe and dramatic. You heard testimony from Mr. Thorley about the significance of the canvassing deadlines and the elections that would slip if the canvassing deadlines are not met, including the Supreme Court election, the election of presidential electors. And when you couple that with Mr. Gloria's testimony that he is certain that they will miss the canvassing deadline if the Agilus machine is somehow not able to be used, this is a very serious situation. And from there, I pull back to the case that I cited in my opening and that counsel for the secretary just cited, Tam v. Colton, where there the Nevada Supreme Court said at any time close to an election, and there it was a couple of months as opposed to 6 days, mandamus is not an appropriate remedy for changing an election at the last minute. And I would note also, Your Honor, that during this proceeding, literally about an hour and a half ago, the U.S. Supreme Court refused to modify a ruling of the Pennsylvania Supreme Court relating to when ballots can be received, saying it was just too late to make a change in the election at 6 days before election day. And then, Your Honor, also with respect to the challenge provision that they are attempting to challenge, basically facial constitutional equal protection challenge. First of all, that provision, as I think I said in my opening, has been on the books since the late 1990s. And here we are for the first time hearing a constitutional challenge to it, which is just simply way too late. And also, there's no demonstrated injury of vote dilution, which is essentially what they're claiming. There's nothing in the record that proves vote dilution. Multiple courts, including courts in Nevada, have held that vote dilution is not a sufficient injury to make out an equal protection claim. And so that's just another example of the petitioners wanting you to essentially ignore what the law is in Nevada and require something that isn't there. There are reasons why there are different procedures for in-person voting and mail-in voting. They're not similarly situated voters. The processes that surround in-person voting and mail voting are fundamentally different. And just because they're different does not mean that that gives rise to a constitutional equal protection violation. Your Honor, if you bear with me one moment, I just want to look at my outline and avoid repeating some of what other counsel have said. I have a handful of additional points that I'd like to make. Your Honor, the thrust of the argument also is that the petitioners are entitled to, quote, meaningful observation. And they repeatedly suggest that's somehow in the statute, when in fact it's not. There's no use of the word meaningful. There is reference to counting only and meaningful observation, which they use to be able to try to justify walking around the building and observing all these different processes. It has not been envisioned by the legislature. Observing counting of ballots has, and that is the only thing. So I just wanted to make the point that they cite Webster's dictionary, but they don't cite the statute for that proposition that one can have sort of unchecked ability to walk around the election office, to view auditing, to view duplication. It's just limited to counting. Your Honor, just a couple of more points, which is, I'll just conclude by emphasizing that if the court were to grant the relief that's being requested, to really stop the processing of ballots, the counting of ballots in its tracks, that the consequences, not just for Clark County voters, but for voters throughout Nevada would be severe. There would be very severe consequences. And the fundamental relief that the petitioner is seeking is something they could have sought quite a long time ago. And for them to be in here on the eve of the election to try to disrupt in this way and to ask you to give relief that's not supported by statute is, one, equitably estopped, two, completely improper for a petition for mandamus. And so, Your Honor, I ask that you deny the petition. Relatedly, I also ask that you protect the voters of Clark County from being subjected to procedures that other voters throughout Nevada would not be subjected to. And that's where the real equal protection violation lies in this case, not with what the petitioners are alleging. So in sum, I ask you to bear in mind, this is mandamus, the bar is high, that the consequences of changing midstream like this are severe, and that what they're asking for is simply not supported by statute. And their evidence has not demonstrated that the county is interfering with observing ballot counting, which is what the observers and the public are entitled to. So thank you, Your Honor.
Thank you. Mr. Hardy, Mr. Binnall?
A chain is only as strong as its weakest link. You cannot say that you can have observation in some areas where there are ballots that are out and about and not in others. Because if there are those, that want to take bad acts, if there are those that want to poison the ballot pool with fraudulent votes, they will find the weak link. They will find the areas where they can take their improper acts in the shadows rather than in the sunlight. All we're asking for on the observation is that you take away the shadows. All we're asking for is observation. The Democrats, as interveners, are arguing that it has to be observation. It doesn't have to be meaningful. There's nothing in the statute that says meaningful. But the fact is, in the statute itself, it says it has to be observation, and then you go look what observation means. And observation means meaningful. There's no other way to have observation if it's not meaningful. What's the point in allowing people to observe, allowing the public in to make sure that there's a way to protect these ballots if it's not meaningful? We ask that you just look at the definition of the word observation and see that it is incorporated right in there. And the statute does require that. In our reply, Your Honor, I think we very concisely, probably more concisely than I gave you a few moments ago, list the relief the court should take in order. The court takes those acts that we recommend in our reply and grants mandamus. We will work quickly and promptly with Clark County. And that's on page 14 of our reply, where it lists the 5 items of relief that we're asking for. Then we can work quickly, promptly with Clark County to make sure that the observation systems are set up promptly and in a meaningful way that both protects the ballots, protects public health, and protects the rights of voters from being having their votes diluted. This is not an abstract injury. They have a public duty to make sure that this happens in the sunlight. The legislature has said there has to be a plan for observation. Saying that this is an opportunity for abstention, saying that that there's not this public duty when it's very clear that the legislature has provided for it. And you have seen witnesses who want to engage in that observation show that this is an injury that is proper for mandamus, because it is clear what the legislature has ordered, that there be an opportunity to observe. As far as the Secretary's argument that ballot secrecy would be somehow limited by this, we're not asking to limit ballot secrecy at all. We're the ones here that are asking the court to protect ballot secrecy. We're not asking that you say that ballots always have to be married back to their envelope all the way along the system. We're asking for the exact opposite of that. All we're asking for is that before the ballots are separated, we have a system in public view to be able to determine that that is a proper voter who is casting that voter's one vote in this election. That's all we're asking for. And that there be a challenge procedure as required by equal protection. They don't have to open it. They don't have to marry it to the envelope. And the idea that this is something that doesn't lie because the entire electorate is affected. The entire electorate, the honest voters, are having their votes diluted. And when it comes to our equal protection challenge, that's a particular class of voters. It's only people that are voting in person that are having their votes diluted because they are subject to challenge. And others are not. Now, they have tried to argue that there's no standing for that argument. That's just not so. It's very clear that there's binding standing, there's Supreme Court case law, all of which we've cited, that talks about the danger of debasement among voters, and even a trifle is enough for standing. The standing, the petitioners do have standing in this case in order to make their equal protection challenges. They have their standing because of the public duties at issue in order to make sure that ballot secrecy is protected. They have standing to make sure that there is a right to observe, a meaningful right to observe. Mr. Gloria argues in closing that the statute doesn't provide for a meaningful opportunity to challenge, and if so, you'd have to find somebody from the same precinct. We are asking simply that you apply the same rules to people that vote in person as to people who vote, who are able to challenge people voting by mail. But that means, of course, that you're going to have a lot of people from every precinct to be there while they're processing. The better way to do this is to just simply say there is a right to challenge for people who, a constitutional right to challenge in this case, because those who are voting in person can't be the only ones subject to challenge. The excuses for Mr. Gloria to not allowing challenges, and first, of course, arguing that they do allow challenges, but then, once we actually see the documents for them, they really don't. The excuses that we get are not good enough. It's notable that none of my colleagues tried to argue that the ballot secrecy laws that we're here to uphold, the secrecy of the ballots of Nevada voters, should be continued to be ignored, or try to make excuses for the current practice in Clark County. One of the most important things, and it's really uncontested, is that the court should issue mandamus saying that they cannot continue with the system of the sequential stacking of envelopes in such a way that the ballots can be married back after they've been separated. Once those ballots are separated, they have to go their separate ways, and it must be forever. As far as the Agilis machine goes, the legislature in AB4 required that the clerk or an employee match the signatures. There's other things that they can do electronically. There's plenty of things they can do electronically, but the statute saying that they can do things electronically says as long as it doesn't violate one of the other sections. So, for instance, the best example here, like I previously said, is they can scan the signatures electronically and give them to their employees. They just can't use artificial intelligence to match the signatures electronically. The idea of latches here simply doesn't lie, because we acted promptly upon learning that Clark County hadn't provided a plan as it was required to do over 6 months ago. And within a day of the secretary responding to that plan, we were before the court. It's very, very difficult to see a situation where we could have acted more promptly. Not only that, but the prejudice in this case is not only to the petitioners, not only to the respondents, it's to all Nevada voters because of the dilution that's at issue. We're not asking in mandamus to create any policies. We're not asking to ignore statutes. We're asking for the enforcement of clear statutes. Statutes that say that there has to be observation, there has to be a plan for observation. The secretary is to provide for it. And as the court has previously mentioned, past practices are not necessarily good practices. Just because they have quite frankly, ignored the statute for some amount of time. Doesn't mean they get to keep doing it. And in this case, you can't even say silence is acquiescence because the letter they send isn't silence. The letter they said, they said specifically, says these are the things we want you to do. It doesn't, if you just look in the ray line of Exhibit 8 itself, it's very clear that that is not a silence by acquiescence approval. Mr. Glory did not say that he was certain to miss the canvassing deadline, and I encourage the court to look at the record. If they can't use the Agilis machine, the artificial intelligence part of the Agilis machine to match votes. It might be difficult, but it's something that's required by law. And it is more important that we get this right than get it quick. There's too much at stake. As for the dilution standing and whether there is standing for that, we asked the court to look at the Kemp case, the Schrager case out of the Ninth Circuit that we cite. Of course, we cite Supreme Court case law on standing and equal protection as well. I'm not going to go over that more. We don't want the system to stop. We don't want to delay elections. We don't want to delay results. We just want to ensure transparency. We want to make sure that the voters, the honest Nevadan voters have their votes protected. That's all we're asking for. We ask that you grant our petition. Thank the court for its time.
Thank you. The matter will be submitted. We will have a decision out to you as soon as possible. Anything else before we disband?
No, thank you for your time, Your Honor.
We'll be adjourned. Thank you.